Right, this is LAWS12066 Land Law, and this is the lecture on topic 9, easements. Topic 9, folks, we're almost there, just one more topic to go, but this topic is easements. Now, easements are slightly different sort of proprietary entitlements. They relate to what has been referred to in the arcane terminology, which we identified right back in the term 1 unit, of incorporeal, what are referred to as incorporeal hereditament, or rights with respect to land, but doesn't give you fee simple interest in the land. So it's not about ownership, but it's about rights and burdens in relation to use, actually. So we'll just start by sharing slides. There we are. We're dealing with easements. And where are we going with this topic? We are wanting to work out what an easement is, how to identify it, spell out its features or its characteristics, to understand how an easement comes about, comes into being, how it's created, how it can be brought to an end, how can it be extinguished, to identify and to articulate also, this topic is not only about easements, but it's also about another type of right that's referred to as a profita prondra. So we'll come to that just towards the end of this discussion. Important just to have a general awareness and understanding of profita prondras. And the other point which is important in this topic is that easements can actually be registered on title, on Torrens title, so they can appear on the indefeasible title in Queensland under the Queensland LTA. So we'll see shortly that there are critical provisions within the Land Title Act and also within the Property Law Act which relate to easements. In terms of provisions within the Land Title Act, that also means you can have a look at, and it's relevant to consult the Land Title Practice Manual, which helps to explain various features of provisions under the LTA with practical application, procedure, forms, and so on. And that's dealt with in Part 9 of the Land Title Practice Manual, which we'll come to shortly. And there's, as I said, also implications of the Property Law Act. And insofar as the Property Law Act is relevant, then of course be mindful of the 2018 review of the PLA, discussion within that document with regard to easements as well. And then this is a topic, of course, which is to be assessed in the final exam. So be mindful of that, folks. And that's where a topic coming at this stage in the unit will be assessed, and you already have advice on that. So and of course this is in your chapter 10 of your casebook as well. So we've got some key ideas there: easements, profita prondra. We've also got this idea of with regard to easements, dominant land, servient land. Dominant land, servient land. There's another topic that is often done sort of in conjunction with this topic. We can't fit it into this unit, unfortunately, but that's freehold covenants. Freehold covenants are agreements that parties entered into, again, with respect to rights and responsibilities over land. And they operate differently to easements, but often they sort of can be sort of a bit in conjunction. you can have a look at that if you're interested, but we're not covering it specifically in this unit. We're covering easements, but just bring that to your attention. So, mindful that I mentioned the Land Title Act, and this is dealt with primarily under Part 6, dealings directly affecting lots, and Division 4, and now 4 capital A. Division 4 dealing primarily with the provisions around easements, sections 81 capital A to 92. Division 4 AA, as evident by the numbering system, has been an amendment to the LTA to incorporate what are referred to as high density development easements in sections 93 to 96 capital E. Profit or prondras are dealt with in Division 4B, sections 97 capital E to 97 capital M. So, and that amendment with regard to high density development easements, that's a specific set of provisions in Queensland. It's not replicated in other jurisdictions necessarily. So be mindful of that and be mindful of those provisions. The Property Law Act, relevant provisions there, 176, 178, 179, 180, 181, and then also 239. In particular, note Part 11, capital A, with regard to rights of way. We'll see shortly there are different types of easements that we can discuss. The right of way is often a very typical easement that comes up in practical situations because it's about access often to something over land, and then it's about how the easement has been established for the purposes of giving that access, and what are the rights and responsibilities with regard to that in terms of the landowners in relation to which the easement is associated. And it has this effect of giving rights, but also burdening, this idea of dominance and servience, which is the more technical land law terminology that comes up, and that's quite important. Just in passing, just make a note that rent charges, and you can see those and how they're discussed in your materials, but they've been abolished in Queensland as a result of, again, provisions in the PLA section 176. So just before we get to the nature of an easement, I'm just going to share the legislation just to give you a better idea of that. So there we are. We see that Land Title Act, Part 6, Division 4, easements. And you can see there that it's dealing with a range of matters: definitions, creation, registration, as I mentioned before, registration of a plan showing the proposed easement. And this is interesting because easements can and do appear on title and on survey plans, and I'm going to show you a plan in the Currumbin case, which is a relatively recent decision of the Queensland Court of Appeal. Shows you a plan. So it has when we look at and think about easements, there's a spatial way of understanding easements, which is quite helpful for those of us that have learned better by seeing pictures and diagrams and so on. So that's the case. These provisions deal also with matters of limitation, how the instrument affects both freehold and non-freehold land, and so on. You can see there a range of matters that are dealt with under the legislation, that is the Land Title Act. If we come across to the Land Title Practice Manual, you'll see that Part 9 is dealing with easements, And, you know, there's a range of material there that's explaining and discussing the various features of easements as they are dealt with under the LTA. And as ever, the Land Title Practice Manual not only has that and explaining, for example, gives examples of easements, which we'll come back to just shortly, different types of easements that are possible. But in terms of like the way in which the easement can occur from a presentation perspective, or how it gets registered on the system, there we go. We can see Form 9 deals under the LTA, deals with an easement if you wish to register an easement. And you can see there various features of the form, including the purpose of the easement. In this particular example, it's a right of way. You can see the various features and so forth that are there. And then there's a guide for completion of the form, which is always very helpful. Okay. And then just coming back, so I'll just stop screen sharing that for a moment. And I just want to come to the all right, we might come to that shortly. So just come back to the slides. So they're the provisions of the LTA and the Property Law Act that we need to be mindful of. We'll come back and have a bit more of a look at the PLA shortly. So when we're talking about an easement, what is it we're talking about? If land is burdened by an easement, that's the servient land. So the servient land is the land that's burdened by the easement, upon which the easement exists, if you like, is transferred, then the seller is no longer bound person. The obligation imposed by the easement passes to each new owner of the land, and the obligation remains only for as long as the land remains in that person's ownership. So the easement attaches to the land, it's not personal to the owner. Similarly, if the land which is benefited by an easement, the dominant land, so it's the dominant land that is deriving the benefit of the easement. So, for example, in a right of way, that's the land that's getting the benefit of use of the easement for purposes of access, for example. But if the dominant land is sold, the benefit of the easement passes to each new owner as soon as he or she becomes, or only for as long as each remains the owner of the land. The easement may be positive or negative in nature. Okay, so there's this idea that the easement attaches to the land. It's not personal to the owners of the land, even though, of course, the original owners have created an easement and entered it and registered if it's on the system in terms of Torrens title under the LTA in Queensland. When we think about the characteristics of an easement, we come to a fairly historic decision of re Ellenborough Park, which is an English Chancery Court decision from 1956. And you will see the Ellenborough Park decision discussed for you in your casebook at 10.13 capital C, or starting at page 957. Basically, within the Ellenborough Park case, we had certain features that were identified as fundamental characteristics. So basically, what the court said in Ellenborough Park is that there must be a dominant and a servient tenement, that the easement must accommodate the dominant tenement, that the dominant and servient tenement must not be held and occupied by the same person, and the right must be capable of forming part of the subject matter of the grant. Just stop screen sharing that for a moment. All right, so what we now need to do is just to work our way through those characteristics as explained in the Ellenborough Park decision. So I'll just go back to screen sharing the slides. And so they're the four characteristics. So in terms of formal requirements for the creation of an easement, in Queensland, we're looking for the execution of formal documents, and under the, with regard to Torrens land, the LTA, we have the registration of easements on the certificate of title of either the dominant or the servient tenement, or in most cases in both of those. And on registration, the easement becomes indefeasible and gets that protection. So these are important features to understand about easements, and that the easement, if it qualifies as an easement, and this is something that was investigated in Ellenborough Park and also subsequent case law, that if it qualifies as an easement, then it attaches to the land. And that's very important, because then it passes when the ownership of the land passes. It's not personal obligation that's entered into by any particular owner. We can also have what are referred to as easements in gross, and these are in favour of the Crown, or in Queensland the state, or local or public authorities. So that's one party to the easement, and that's the one that's being benefited by that easement. So that's a particular type of easement that you just need to be aware of. In terms of accommodating the dominant tenement, the Close Farming Estates and Eastern decision, which is in your case book, at 10.14c at page 960. This is a decision of the New South Wales Court of Appeal in 2002. Basically, we had a situation where we had a developer, we had various lots being able to be owned independently. We then also had a lot for developing viticultural purposes, growing grapes, vineyards, and so forth. What happened in the way that the developer had set up the development and the selling of the lots and so forth was it imposed a restriction, and in the case it was referred to as the 14th restriction, which was effectively identified as an easement for vineyard. Multiple owners of lots on the estate could operate a single viticultural production unit through Close, the developer of this, who had the right to control and manage and operate and sell product. In due course, Close lodged a caveat in relation to the lots over which this related to. And one of the questions that arose was whether or not this easement for vineyard was actually a valid easement. And what the court found, and you've got judgment of Justice Appeal Santow from the New South Wales Court of Appeal, was that the 14th restriction in terms of being this easement for vineyard did fail in the end, because the second and fourth conditions for the creation of a valid easement under Ellenborough Park were not met. And this related to the easement must accommodate the dominant tenement. There must be a connection of land and industry, and not just a mere convenience. So in other words, there must be some benefit going to the dominant tenement. That's the critical idea here. And the right claimed as easement must be capable of forming the subject matter of the grant. The pure commercial interest in and of itself, though possible, it can give rise to an easement, is not necessarily sufficient to justify the identification of an easement and a right in the property, which we've seen previously referred to as a right in rem. So have a look at the close farming case with regard to the accommodation of the dominant tenement. It's important to appreciate that there's been some change in Queensland. So this idea that dominant and servient tenements must be owned and occupied must not be owned and occupied by the same person, which was one of the characteristics laid down in Ellenborough Park. That's been changed in Queensland. So according to change instituted under the Property Law Act, that's no longer necessary in Queensland. So just be aware of that. In terms of the easement must be capable of forming the subject matter of the grant. Again, this is the fourth condition in Ellenborough Park. And this depends on whether the right is conferred as too wide or vague, whether it's inconsistent with proprietorship or possession of the alleged servient owners, and whether it is a mere right of recreation without utility or benefit. So this idea of it being subject matter of the grant is it has this connection to the land. It is benefiting the dominant tenement or the dominant land, and it's sufficiently described with precision to be able to be identified what the nature of that benefit is. So you need to examine the documents, you need to examine the wording. This is also raises this idea that as property lawyers, one of the things, the areas of work that we get involved in is actually drafting up the terms of an easement. And one has to do this with care and attention to detail, because if at the end of the day you're not meeting these characteristic requirements, then you may actually not have an enforceable easement. And that will be diabolical if the intention, of course, is to create an easement. So that's really important. This, again, a bit similar to what came up when we discussed the rule against perpetuities, is that we must pay attention to detail in our drafting and how we're using language to satisfy the legal requirements and meet clients' intentions. Now, again, today, in our practice, of course, we have access to technology, we have access to precedent clauses and terms and covenants. Increasingly, for example, through algorithms, artificial intelligence, these can be generated and created. They can even be created with specification and specific focus on what the client has required. So the issue then becomes, well, what is the role of the lawyer if that can be done, for example, through an algorithm? One of oversight and one of working with the technology in terms of ensuring that the requirements of the law are being met and that what the clients are seeking has been achieved. So it's an indicator, in my view, that the nature of our role is changing, but that there will be a continuing role for us in terms of working, if you like, between the technology and our clients to produce the outcomes that they are seeking, that are enduring, and in this case, we're creating instruments, property law instruments that are enforceable, and we're working with the technology to do that in the best way that we can. So that's, update in terms of how, the application of this area of the law that we're looking at the moment, or land law. You can see there in the slide just a few indicators of how we tackle this idea of the fact that the easement must be capable of forming the subject matter of the grant. You can have a look at how that's discussed further in your materials. In the context of the Ellenborough Park case, there was this idea of the right to use the garden and its connection to the adjoining properties that were adjacent to that park. And it was a pleasure ground, in quotes, of the times. And in the Ellenborough Park decision, that had been taken over during the war for war purposes and various other uses. But ultimately, it came back to this idea of how did the easement work in terms of use of the park and its connection to the adjacent lot owners, lots, which the owners are being sought to get a clarification from the court in regard to the nature of the easement. So there's some discussion there, and just today we also see there's some more recent English law on this, case law, and that's the Regency Villa or Villa title decision and Diamond Resorts. Just stop screen sharing that for a moment. So we'll just come back again to the slides and the Regency Villas case, which is the recent 2015 English decision. And you'll find that in your casebook at 10.17c in relation to accommodation of the dominant tenement, and also at 10.21c in relation to the easement must be capable of forming the subject matter of the grant, and that's where we're looking at it at the moment. And this is a recent application, and even though it's in the English context, the judgment of the court, the Chancery Division of the High Court of Justice in England, refers to Australian law. So you'll see, for example, on page 964, there's reference to the Riley and Pentilla case, which is a decision of 1974 decision of the Victorian Supreme Court in relation to the applying Ellenborough Park. The essential point coming out of the Regency Villas case, applying Ellenborough Park and following the close farming decision, is how do we determine whether something actually is an easement? And one of these ideas, this notion that it has to form part of the subject matter of the grant, is that it relates to the land and that the dominant tenement is being benefited. And where the easement is in relation, for example, to recreation facilities, in the context of Regency Villas, there were sporting facilities and a timeshare complex where various lot owners had timeshare arrangements in terms of their entitlements as lot owners, and then the complex was under the management of the Diamond Resorts. Is those access to those facilities just merely pleasurable, or does it somehow benefit the dominant tenement? You can see, for example, in the judgment, this is on page 963 of your casebook, of Justice Pearl, he talks about mere rights of recreation. And he then goes on a bit further down, he looks at Ellenborough Park, and then that sort of second paragraph is judgment on 963. The object that a mere right of recreation cannot take effect as an easement is therefore apt to mislead, unless the limits of the proposition are understood. The key may lie in the use of the word mere, which may connote a right which does not benefit dominant land at all because there is none. And he gives him some examples, and then he says, outside those examples, rights of recreation can take effect as easements, so long as they accommodate the dominant land, are not too wide and vague, do not amount to rights of joint occupation, and do not deprive the servient owner of proprietorship or legal possession. Okay, so that's clear in terms of the relationship between the dominant and the servient tenements and the owners of those land at the time when the ideas are being explored in terms of the enforcement of the easement. If you come across to the further discussion of the Regency case, starting on page 966 to 7, it again a further exploration of the fact that in that case there were sporting facilities and a swimming pool. And does that, are they the sort of things that can, be qualify in terms of those characteristics that we're talking about to be an easement? And you can see, for example, over onto 967 again, this is the judgment of Pearl. The rights granted are to be construed as entitling the claimants to use the facilities and gardens subject to proper restrictions and regulation made in the ordinary course. He then looks at Ellenborough Park, and then in the following paragraph, there are many examples of easements which cannot be enjoyed by all dominant and servient owners simultaneously, of which perhaps the most prosaic example is the use of a toilet. So that's a really interesting observation, but a practical one. And in the end, basically the court finds that these sporting facilities and so forth as part of this timeshare complex, yes, that this is a legitimate easement and they are deriving benefit from it. It is not just, to go back to look at those, the characterisation at the beginning on page 963, it is not just this idea of the mere rights of recreation. And yes, it is arguable, of course, that there can be a fine line of distinction here, and that's to be determined by an examination of the facts. But this has important implications as to whether or not we are looking at an easement or we are not. And there we come back to this important idea about how it's drafted by the lawyer, maybe in conjunction with technology, not only in terms of fulfilling the intentions of the landowner at the time, your client, in terms of the creation of the easement, but mindful that this is going to attach to the land and also bind subsequent owners, subsequent dominant and servient tenements going forward, because it can be registered and then it will acquire indefeasibility under the LTA in Queensland if it is registered. Okay, so these are the dimensions of thinking about easements in terms of how they operate and function, and also in the context of Torrens land. All right, so in terms of thinking about types of easements, again there, see reference to Land Title Practice Manual Part 9, and I've already shown you that a little bit earlier in the lecture. We can look at things like rights of way, very important and very typical and sometimes contentious. We can also have matters like support for buildings, party and shared walls, particularly, for example, in duplex dwellings where maybe one original house detached dwelling has been, two have been created from that, and then there's a wall that's shared between the duplexes, or those not just created from one dwelling, but actually duplexes can be built from scratch, as it were. Drainage and sewerage reticulation, water storage, retention of light or air, electricity transmission, encroachment, and eavesdrop. And you can have a look at how those are discussed in the Land Title Practice Manual. Now, in terms of one of the most significant types of easements that's available, that takes us in turn to the rights of way. Now, there are two, there's both provisions within the Property Law Act that we need to be mindful of in this context, and also the two Westfield management cases. The first decision and then the appeal that went to the High Court. So the first decision is the Perpetual Trustee in Westfield Management 2007, and then we have the Westfield Management and Perpetual Trustee High Court decision 2007 also. But we also need to have a look at the, in this context, the Currumbin Investments decision as well, which I'll just refer to shortly. Just note that property law provisions deal with both rights of use or access to light or air, and also specific provisions with regard to rights of way. Now, I'm going to focus on rights of way because it's quite sort of, it's a common area, and we've got case law on it. We've also got legislation on it. So I'm just going to start by coming back to the legislation. Right, so in terms of rights of way, we have some specific provision within the Land Title, in the Property Law Act. I'll just show you that. This is section 198 capital A under part 11 capital A of the Property Law Act. Now, this was inserted in 1975, and you can see there in sub 1 that it says, this is in regard to a prescriptive right, and we'll just refer to what that means in a moment. User after the commencement of this act, and it's important, after the commencement of this act, of a way, that means a right of way over land, shall not of itself be sufficient evidence of an easement of way or a right of way having been acquired by prescription or by the fiction of a lost grant. So I'm just going to stop screen sharing that, and I want to show you the section from the PLA Review 2018 dealing with section 198 capital A of the PLA. So this is on page 785 of the report. So this is basically giving you a bit of background in terms of the enactment of 198 capital A, and basically removing the right of a prescriptive easement of way after the enactment of these changes, which you can see there had effect from 1975. This idea of prescription was basically this idea of longer user. So merely by use over time immemorial, forever basically, that created the easement. And this, as you can see there, there's discussion going right back to the early period in English history, even as far back as the 12th century, 1189. And as we know, property law, land law, has this enormously long pedigree that goes right back to the Norman conquest, and maybe even beyond that. But certainly, we have benchmarked as our start point back, which is only 1,000 years of history there. But we're not focusing on all of that detailed history. But it's interesting to see where some of these ideas and notions originated from. Now, what I want to show you from this was that, so you can have a look at this discussion, and also there's comments there, the prescriptive with regard to other prescriptive easements in regard to other matters that you can have a look at. But and there's useful discussion around different jurisdictions. But what I wanted to show you was, we come down here. Now, this is on page 795. So basically, the review is recommending that 198 capital A be repealed. Interesting. Okay, what are they recommending? They say that instead we should insert provisions that declare that no interest under either the Land Title Act or the Land Act can be created by prescription or through the fiction of lost modern grant, irrespective of when created, when the time the amendment is passed, and declare that easements that may previously have been created by prescription, that is longer user, or by the fiction of a lost modern grant, may only be sought under section 180 as statutory rights of user. So they're reconciling those that had been recognised prior to the reforms being enacted. But essentially, they're saying that rights by prescription, these provisions should be repealed, and just a clear, plain language reform there dealing with the fact that this can not be possible in relation to developments after the enactment of these reforms. So that's interesting, just to be aware of those proposed changes. So we'll just come back to the slides. So in light of those legislative features, we need to be aware of important case law in this area, and the case law that's relevant in this context, as I mentioned to you before, is these two decisions of Perpetual Trustee and Westfield Management, and then the High Court Westfield Management decision. This were basically cases involving, some same facts went on appeal to the High Court. It basically was a dispute involving the glasshouse building in right in the centre of CBD Sydney on Pitt Street. And basically there's a complex of buildings there that were owned in some cases by similar owners, and a grant of way burdening its property and benefiting the owner of Sky Garden. So Glasshouse and Sky Garden were two different buildings. Was it a right of way for persons and vehicles to go to Sky Garden as well as Imperial Arcade and Centrepoint, or Sky Garden alone? Now, this was decided in 2007. Some of these areas don't actually exist after a redevelopment in the CBD of Sydney, but nonetheless, the principles continue to have relevance. So the court's looking at the extent of the use. Will not be construed beyond the use contemplated by the parties at the time of the grant. The easement must bind the survey and tenement, not just the parties. So again, this connection to the land. Ambiguity in the instrument would be construed against the grantor. After looking at the instrument itself, easement did not entitle owners of Sky Garden to authorised use of easement access to Imperial Arcade and Centrepoint. Now, when we come up to the High Court decision, and you can have a look at these cases, further analysis of the cases in your casebook under the subheading types of easements, further subheading rights of way. So perpetual trustee and Westfield management 10.33 capital C, and then Westfield management and perpetual trustee 10.35 capital C. And basically that's from pages 975 through to 981. Now, before the High Court basically agreed that the omission of the words "and across" in the instrument indicated an intention that the easement was not intended to provide access to the remoter land in this particular configuration of the buildings, and that the apportionment of expenses and responsibilities indicated an intention that the easement was for the benefit of Sky Garden only. And the High Court also made some general comments about the intention test in the context of the case. So you can have a look at these are cases that help to clarify the nature of whether we have an easement in the circumstances of a right of way, and we've now got this High Court ruling. But subsequent to this, in Queensland, we have the Currumbin Investments case, which was decided by the Queensland Court of Appeal in 2012. So I'm just going to go to that. Right, so I'm just going to screen share Currumbin Investments, and you've got a copy of Currumbin Investments on Moodle under this topic. And what's really interesting about this case is that we've got a diagram, something nice and spatial, and we can see the land. And this is one of the really things I think about land law, is that it's not just about all these technical rules that are all textual and getting a candle around those features and characteristics, but particularly in this area of something like easements, we can actually look at a diagram and we can see how it is on a survey plan and how it is created and identified there, and that can help to explain the benefiting and the burdening with regard to the dominant and servient land. Okay, so there's a diagram there that's on at paragraph 8 of Justice Freiberg's judgment, right up front, which was good. A bit further into his judgment, so he goes through and looks at the various matters and so on, the dispute and appeal and whatever. What I want to show you is, which is quite useful. So looking at the various the easements that are in play and are in dispute. But what's relevant and helpful for our purposes, just getting to it. I think it might be just a little bit back. Right, so starting at paragraph 39 of his judgment, it's Freiberg's judgment, he looked at the case law. Wonderful. Looks at the Westfield decision, looks at the Court of Appeal, New South Wales Court of Appeal decision in Westfield, and gives a nice explanation of that for you. It then looks at the unanimous judgment in the High Court. Wonderful. And focuses in on the critical aspects of that, which is very helpful for us as ever. And then also really useful, it puts it into the context of Torrens land. And so he then ties that together in terms of what is the implications of that, in terms of where you find the easement and the information revealed and so forth, and you cast your mind back to interfeasibility, and then what, in terms of, you can see their reference to Bursell and Berger Brothers, which is about, well, what can you go to, what can you examine in terms of the nature of the easement. And in fact, it was in the Bursell and Berger Brothers case that was also looking at easement, and what were you permitted to have a look at for purposes of determining interfeasibility. So Freiberg does that, which is really helpful and good. And then he goes on and looks at some further case law, which you can see there. Have a look at that. And then there's just one more point I want to, which we've got to. So it's quite a good overview of relevant law here. And then he also looks at application of cases of easements under the Torrens system in Queensland. Even more helpful, okay? So then he's going through and having a look at some of that. So you can just have a look at those materials and what the judge is looking at in terms of determining and coming to the conclusion as to whether or not in this particular situation we have an easement or no. So have a look at that, those parts of the judgment of the Currumbin decision, which I've given you on Moodle, and which I've now pointed out to you quite specifically. And also the fact that the diagram is, you can have a look at that and you can get a spatial sense of how easements work a bit. So this is dealing with rights of way, and I've also just referred to the matters there in regard to the property right with regard to right of use and access to light and air, and also the proposals of the 2018 property law review in that regard. Just going forward, we can have a look at a few other examples. So party walls under the common law, where the common owner where the common owner sold buildings that were mutually supported by a party wall, cross easements implied as necessary to carry out common intention of the parties in relation to the use of the wall. So cross easements between those adjoining lots of land. But also now we need to be mindful of the implications of high density easements under Division 4AA of the Land Title Act, and how these involve small lots and common walls in high density dwellings, apartment complexes and so on. So just have an awareness of that. Okay, these reforms, important developments in the law in Queensland. In terms of creating easements, we can have express or implied easements. So basically we can set these up either by having been expressly created by the parties through a transaction. They may be implied, they may be acquired by longer use or prescription. We've seen how the law in Queensland has responded to this idea of prescriptive easements, and they can be created by court where that's thought to be reasonably necessary. So in this context, be aware of the implications again of the Property Law Act Section 180, which permits the court upon application to create an easement in the interest of effective use in any reasonable manner of the land. And you can see a recent case example of that of Purlian and Aegis, which is a 2015 decision of the Queensland Supreme Court. Right. So that that decision of Purlian and Aegis, you'll find that at 10.100C of your casebook in relation to Section 180 easements that have been created by court order. So that's on pages 1019. We've reached page 1000 of the casebook. We have. 1019 through to 1022. So you can have a look at the AGIS case with regard to section 180, which is a useful recent example in Queensland in relation to the Queensland provision with regard to the court's power in terms of creating easements. Implied easements arise where the parties have failed to expressly create an easement, but the easement is necessary for the proper enjoyment of the dominant tenement, so the circumstances can arise in those situations. Easements may be impliedly granted in one of 5 ways. So we can have the rule under Wealden and Burrows, by general words, by necessity, by common intention, and by a manner of description of the property. And you will find a discussion of Wealden and Burrows at 10.79 capital C of your casebook, back starting on page 1005. Now, just moving on, so we need to, then we need, following about the creation, we can think about the remedies that are available. We can look at, for example, these ideas of abatement. Damages for nuisance is also possible, injunction, declaration of rights, damages. You can see that some of these are the sorts of remedies that are available in equity, injunction, declaration of rights, and so on. There's also recourse in some circumstances to section 279 of the Queensland Criminal Code. So just be aware of those types of remedies that are available, where a dominant tenement holder, for example, can prevent interference with an easement, and what sort of remedies are at their disposal. And you can see remedies discussed on page 1025 of your casebook in that context. From there, we look at extinguishment of easements, and how might an easement be extinguished, brought to an end? Well, this can be done by abandonment. There can be an express release that the terms of the easement have been, there's been a sense of unification between the dominant and servient tenements, where there is an alteration in use of the dominant tenement, such that the benefit that is derived by the dominant tenement is no longer justified. As I said, the unity of dominant and servient tenements, and that's dealt with under Section 88 of the Property Law Act. And then importantly, Section 181 of the Property Law Act by order of the Supreme Court. So you can find the discussion of extinguishment of easements starting on page 1026 of your casebook. Right, so we just screen share again, those slides. So the two of these types of extinguishment which probably arguably are more significant, and that is the idea of abandonment, which is something that practically happens. You can see that's discussed in your casebook starting at 1026, and the Trewiki and 36 Wolseley Road decision of the High Court of Australia, 1972 to 73, is important in this regard in terms of determining what amounts to abandonment, and that's quite critical, so that it needs to be determined on the facts at hand, based on the nature of what's transpired as to whether there has actually been abandonment. So that's important to establish that before you can say the easement has in reality been extinguished. And then the power of the court, the Supreme Court under Section 181, you can find statutory extinguishment there on page 1034 at 10.116. Now, before we leave easements, we need to bring to our attention an important factor, and that is easements in the Torrens system. Now, in Queensland, of course, as we've been saying repeatedly throughout the unit, all private freehold in Queensland is Torrens title. So how do easements fit within the Torrens arrangement of the world? So we need to identify, for example, that there is a partial exemption provision within the Land Title Act with regard to indefeasibility, a partial exemption to indefeasibility under Section 185(1)(c), that refers to omitted and misdescribed easements. So where that's been satisfied, that can be an exception to the indefeasibility of the registered proprietor, where you can establish that there has been an omitted and misdescribed easement. Then we have the further idea, and that is the enforceability of unregistered easements. And you can have a look at the decision in Dabbs and Seaman that's referred to there, and the discussion around this with regard to enforceability in those pages that I mentioned from your casebook. So that's just something to be mindful of, this idea of the enforceability of an unregistered easement. How does that work in the context of the Torrens system? And be aware of that. So you can see, for example, that's just the discussion of unregistered express easements on page 1044, and unregistered implied easements on 1045 of your casebook. And there's some more recent law that's considered there. That then brings us to the last point, or the last part of this rather longish lecture, and that is profits a prondra. And you will see the idea of profits a prondra being discussed starting on page 1059 at 10.145. Now, in Queensland, this is dealt with under Division 4B of the Land Title Act. We might just screen share that. So I'll just show you the legislation. So you can see there that Division 4B, dealing with a range of matters, profit a prondra by registration, affecting a lot and a non-freehold lot, land, requirement of the instrument, particulars to be registered, the profit benefiting and burdening the same registered owner's lots, same person becoming registered owner of benefited and burdened lots, and so on, various other matters that you can have a look at there. So Division 4 capital B, relevant with regard to profits a prondra. What do we mean by a profit a prondra? And you can go back and the decision of Close Farming and Eastern is relevant in context of profit apprenders, and you can see that's discussed at 10.147C of the casebook at page 1060. And basically, it's a right to take something off another person's land, where the thing taken must be capable of ownership and be either soil or minerals from the tenement, natural produce, or animals for a nature. Now, we saw this idea of wild animals back in our Term 1 unit, and it's this idea that you can go onto someone else's land and you can take this. So that the idea of gaming was a part of this, and also anything else that qualifies within that context. And then the issue arises as to, well, how do we know if this is a profit that you're able to qualifies as a profit apprender or not? And there was, again, in the close farming decision analysis about with the vineyard and the going onto that land for the purposes of taking, the harvesting the grapes and so on, did that constitute a profit? And there was discussion by the court in relation to that. So you can have a look at the decision in close farming discussed on those pages of your casebook in relation to working out whether or not a profit has been created. Now, just one point to note, just toward the end of your casebook, there is, or 2 points really. One is that we're only concerned with Torrens land in Queensland, not with old system, so we don't need to worry about that. There's some discussion there of the implications of profit apprenders in the context of Torrens land, and just be aware of that brief discussion there. And then in the context of the reforms, there's some discussion at the bottom of 1065 over to 1066 with regard to some reform proposals that have been suggested. Of course, we just need to be mindful of the reform process that's ongoing, and the relevance of that going forward as ever. Right, so that's been a bit of a journey, folks, but there's a fair bit to cover there, and as I mentioned at the outset, easements are subject to assessment in the last assessment in this course, and that's where it falls in the unit, and as you've got information to that effect, that's where it will be assessed. So where do we wrap up? We wrap up with where we started, in a sense, by saying that we've been explaining what an easement is, looking at the essential characteristics of an easement, as not as it's a right with regard to use or access, and it gives this relationship between benefit and burden, or dominance and servience between landowners. Very critically, it attaches to the land. It's not a personal obligation or right to any particular landowner, and it can be registered in the Torrens system under the Land Title Act. We can also see that there are limited exception to indefeasibility with regard to that in the provisions of the Land Title Act, and it can arise in different circumstances. We can have different types of easements. We also, importantly, see the relevance not only of the Land Title Act but of the Property Law Act in this situation. We've seen that there has been proposals for reform in this area under the 2018 Property Law Review report that's been released in 2018. And then lastly, we focused just briefly on this idea of profit apprender. What is it? How do we understand it? And what is its context in relation today to Torrens land, as that's the nature of private freehold in Queensland. So there we are, folks. Easements, profit or plunder. All done and dusted. So, till next time, bye for now.